Antitrust Case India. On 20th October 2022, the Competition Commission of India (CCI) slapped a penalty of Rs 1337.76 crore on Google for anti-competitive practices in relation to Android mobile devices. This ruling was challenged before NCLAT, National Company Law Appellate Tribunal, which is an appellate authority over the orders passed by the CCI. Firstly, let us take a look at the antitrust laws in India. The Competition Act of 2002 is India's antitrust law. It repealed and replaced the Monopolies and Restrictive Trade Practices Act of 1969 on the recommendations of the Raghavan Committee. It was first implemented against India's second largest conglomerate, Tata Sons, in 1960. Antitrust law, also referred to as competition law, aims to protect trade and commerce from unfair restraints, monopolies, and price fixings, and to ensure businesses are engaged in fair competition. The Act prohibits anti competitive agreements and abuse to dominant position by enterprises and regulates combinations, which causes or is likely to cause an appreciable adverse effects on competition within India. The duty of CCI is to eliminate practices having adverse effects on competition, promote and sustain competition, protect the interests of consumers, ensure freedom of trade in the markets of India. Let us take a look at the timeline of all antitrust cases launched against Google in India. Search bias. For search bias and abusing its dominating position in the nation's general web search and web search advertising services, the CCI penalized Google with USD dollars 161.95 million in February 2018. Android mobile operating system. In 2018, two antitrust research associates and a law student filed a complaint, which led to the CCI authorizing an inquiry into Google's alleged exploitation of Android's monopoly position in India. In April 2019, the investigation got underway. According to estimates from Counterpoint Research, about 97% of India's 600 million smartphones use the Android operating system. Just 3% of the market is occupied by Apple, Google Play Store, and Google Pay. The CCI conducted an investigation into the mandatory use of Google Play Store's payment mechanism for premium apps and in-app purchases in November 2020. The investigation also examined if Google Pay, the company's payment service, had abused its dominant position in the industry. Smart TV market. In June 2021, it was requested that the CCI looks into the allegations that Google misused its control of the Android operating system in the Indian market for smart televisions. The probe was ordered as a result of complaint made by two attorneys, Kshitij Arya and Purushottam Anand. News aggregation. The CCI opened a fresh antitrust investigation into Google on January 7, 2023, in response to a complaint by the Digital News Publishers Association (DNPA) on suspected abuse of Google's dominant position in news aggregation. How did Google violate the competition law in India? Smartphones need an OS to run applications and programs, and Android is one of the most prominent operating systems acquired by Google in 2005. It is estimated that 97% of India's 600 million smartphones are powered by Google's Android OS. The Android operating system is run and managed by Google, and other Google exclusive programs like Chrome and Play Store are licensed. The Google apps are then used on smartphones made by original equipment manufacturers (OEMs) or smartphone manufacturers like Samsung. The CCI delineated five relevant markets for the purpose of analysis. Market for licensable OS for smart mobile devices in India, market for App Store for Android Smart Mobile OS, market for general web search services in India, market for non-OS specific mobile web browsers in India, and market for online video hosting platform OVHP in India. Some of the specific practices that the CCI found objectionable were requiring device manufacturer to pre-install Google's apps and services as a condition for accessing the Play Store, prohibiting device manufacturers from pre-installing any competing app store or forked version of Android, bundling Google's apps and services with each other and making them non-removable, giving preferential treatment to Google's own apps and services in search results and recommendations, imposing exclusivity clauses on app developers that prevented them from distributing their apps on other platforms, and using user data collected from its apps and services to enhance its dominance in other markets. Now, despite the fact that Android source code is publicly available and includes all of a smartphone's fundamental functionality, It is missing Google's exclusive applications. Manufacturers must engage into agreements with Google that spell forth their rights and obligations in order to access and utilize these applications in their mobile devices. The Competition Commission India held that with the use of these contracts, Google forced manufacturers that wanted to use its exclusive apps to use its version of Android as payment for pre installing Google apps. The device manufacturers receive a portion of Google's search revenue from their products. This lowers the cost for gadget makers while also enabling Google to grow its user base. Since practically all OEMs were affiliated with Google, alternative Android OS developers, remember it is an open source code which anyone can use, they were unable to find distribution channels for their alternative Android OSs. Additionally, these agreements ensured that the entire Google Mobile suite was required to be pre installed on Android smartphones and that there was no way to uninstall the same. These agreements ultimately resulted in the closure of the market for competitors and removal of choice for customers because they made it impossible for them to successfully compete with Google. Second, Google dominates the global App Store market for Android platform. In accordance with the EU, more than 90% of apps downloaded on Android smartphones worldwide originate from the Google Play Store. According to the CCI, users were denied the option of side loading or installing apps from sources other than the Play Store due to the required pre installation of the Google Suite, which includes Play Store. Thirdly, the firm's dominance in the browser and general internet search markets comes in. Google currently holds a 92% market share for search engines worldwide as of 2021. Because of this, Google was able to achieve exclusivity for its search services to the complete exclusion of competitors by entering into revenue sharing agreements with mobile manufacturers. According to the CCI, the agreements with OEMs gave Google continual access to mobile users' search queries, securing its ad revenue while also enabling continuous service enhancement at the expense of other competitors. The story so far. It may be noted that on January 24th this year, Google filed an application with the NCLAT seeking an expedited hearing in the Android case in order to facilitate its early disposition in accordance with the Supreme Court's directives. The Supreme Court ordered the appellate tribunal to rule on Google's appeal by March 31st in its verdict on January 19th, while failing to interfere with the NCLAT's order of January 4th in the CCI's Android decision. The 10 monetary directives given by the CCI in its October 20th judgment last year have not been stayed by the Apex Court. The CCI calculated that the penalty amount based on 5% of Google's average relevant turnover for financial years 2019-20 to 2021-22, the CCI also directed Google to deposit the penalty amount within 60 days of receipt of the order. The CCI's order is appealable before the National Company Law Appellate Tribunal (NCLAT) within 60 days of receipt of the order. On January 4th, the NCLAT refused to grant an interim stay against the CCI decision from October 20th of last year in the Google appeal matter and decided to admit the appeal with a pre-deposit of 10% of the total $1337 crore penalty. Since then, Google has paid the 10% penalty sum. Google appealed this NCLAT decision that denied a temporary stay before the SC. Google contested the CCI's findings and argued that its practices were pro-competitive, beneficial for consumers and device manufacturers, consistent with the industry standards, and subject to user choice and consent. Google further asserted that its Android operating system was open source and free to use, and that its apps and services were popular because of their quality and innovation. The final verdict. The NCLAT upheld the order of CCI imposing a penalty of Rs 1337.76 crore on Google in a case related to abuse of its dominant position in Android. The tech giant has been given 30 days by the National Company Law Appellate Tribunal to pay the fine and implement the order. NCLAT said that the investigation by the Competition Commission of India into Google was not in violation of the principles of natural justice. A two-member bench of NCLAT said It was unable to accept contention that CCI order on Google is replete with confirmation bias. The CCI rejected Google's arguments and held that they were not supported by evidence or logic. The CCI noted that Google's practices had harmed competition, innovation, consumer welfare, and user privacy in the relevant markets. The CCI also observed that Google's conduct was not justified by any efficiency or pro competitive rationale. The CCI concluded that Google had violated Sections 3 subsection 4 and Section 4 subsection 2 of the Competition Act 2002. The Competition Commission of India fined Google with 1337 crores for allegedly abusing its dominant position in the Android ecosystem, and the National Company Law Appellate Tribunal has ordered Google to pay the fine within 30 days. According to the NCLAT, Google abusing its dominant position by requiring original equipment manufacturers to pre-install apps. Additionally, it has ruled that the natural justice standards were not violated and that the CCI's decision was unaffected by the absence of a judicial member. The NCLAT did grant Google some limited relief, though, by invalidating 4 CCI orders overall, by vacating 4 of the CCI directives in case involving the misuse of Google's dominant position in Android. The NCLAT provided Google, a subsidiary of Alpha Inc., with some relief. The CCI had previously mandated that Google host third party app stores within the Play Store, but this requirement has been lifted since. After the Supreme Court in January refused to suspend any of its antitrust remedies issued last year, the decision will be somewhat relieving for Google. The NCLAT has overturned CCI's ruling to permit users of Android smartphones to uninstall Google's pre installed or preloaded apps. Pre-installing popular programs like Gmail, YouTube, and Google Maps on Android devices effectively creates an entry barrier for new players, especially given that the Play Store can be relied upon to prevent the download of competing apps. Even if Play Store were benevolent and permitted the download of competing apps, users would still be miffed by the storage space restrictions, since more storage space would be required to install the app of their choosing from the Play Store. It is possible that competing Google apps would need to be removed to make room. The key is therefore uninstallation, which Android forbids when it comes to Google apps and which NCLAT has chosen to cover up, maybe under the influence of Google's innocent assertion that such removal would jeopardize the devices and its owner's safety. What's ahead after this judgment? NCLAT's indulgence on this score can have a serious impact on India's burgeoning and promising startup ecosystem. They need to have a free and fair market environment to scale up their businesses, which the CCI was alive to but unfortunately has been lost on the NCLAT. Indian startups must be allowed to rope in their services of a billing system other than Google's. Another instance of abuse which would go on untrammeled is insistence of GPay elbowing out rivals like PhonePe, Paytm, and others from Android-driven cell phones. Running with the hare and hunting with the hound is what the NCLAT has done. This is the risk associated with the desire to render a fair or nuanced judgment when it is not necessary. You collapse between the two stools when you try to balance them. The NCLAT has been taken in by Google's self-serving argument that its anti-competitive actions are necessary evils and in best interests of the consumers. A fine cannot take the place of putting an end to dominance abuse. While we believe Google's actions are anti-competitive, we are nonetheless convinced that a technology owner would logically promote his own apps rather than allowing other competing apps to share. For Indian tech enterprises, the NCLAT order is anticipated to have a substantial impact. The ruling is expected to set a precedent for how major firms in the IT industry conduct their businesses and interact with OEMs and app developers. Please make sure to like and subscribe the video and press the notification bell so that you never miss out an update from us. Thank you.